Okay, I would like to get us started for our next panel. Our next panel is entitled Beyond Sexual Violence, Obstetric and Reproductive Harms. We have my colleague, Professor Fionnuala Nealon, and Anthony Galley, who will be speaking on the topic. And I'm going to do a brief introduction and then turn it over to Professor Nealon, followed by Anthony Galley to speak. So Anthony Galley, he is a PhD student of jurisprudence and social policy at the University of California, Berkeley. He holds a JD from Berkeley Law, where he was a submissions editor for the Berkeley Journal of International Law, Human Rights Center Fellow, Miller Fellow, and the recipient of the Clinical Legal Education Association Outstanding Clinical Student Award for his work in the International Human Rights Law Clinic. He has held legal internships at Witness and the International Federation for Human Rights, and he is currently a researcher in the investigations program at Berkeley Law's Human Rights Center. Anthony's research interests lie at the intersection of international criminal law and emerging technologies, including issues related to conflict-related sexual violence, reproductive harms, digital open source investigations, and the emergence and commission of genocide. Professor Nealon is a University Regents Professor, holder of the Robina Chair in Law, Public Policy, and Society, and faculty director of the Human Rights Center at the University of Minnesota Law School. She is concurrently a professor of law at the Queen's University of Belfast School of Law. In 2017, Professor Nealon was appointed by the United Nations Human Rights Council as United Nations Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. In this capacity, she worked closely with states and United Nations entities to advance human rights protections in some of the most difficult contexts globally. She was reelected by states for a further 3-year term in 2020, and her term ended in November 2023. She was elected to the International Commission of Jurists in 2023. In 2024, Professor Nealon was appointed Honorary King's Counsel by His Majesty the King of England. This is a lifetime appointment. She is the recipient of numerous academic awards and honors, including a Fulbright Scholarship, the Elon Prize, the Robert Schuman Scholarship, a European Commission Award, the Lawler Fellowship, and was a Leverhulme Senior Fellow. Her teaching and research interests are in the field of international law, human rights law, national security law, transnational justice, and feminist legal theory. And now I would like to turn it over to Professor Nealon. We have about 15 minutes for each speaker, and then we will follow it up with questions from the audience and a few that I'll have prepared for them. So thank you, Professor Nealon.
Thank you, Chris. I'm very sorry not to be with everyone in Minnesota. I'm on a research leave in Madrid. So I hope the weather is getting to be as good in Minneapolis as it is in Madrid in spring. And so my comments today focus on centering the protection of maternity in wartime. And I think, as many of us are aware, we've seen attacks on maternity hospitals, fertility clinics, on women's medical centers. And these attacks in sites of armed conflict are visible and they are undulating. In parallel, we see the structural violence of deliberate starvation, water deprivation, the targeting of educational institutions, desalination destruction, and sewage pollution from military targeting, and all of this together harms mothers. This has been particularly observed in many recent conflicts. Gaza is a good example, but is also present in other conflict zones across the world, including ongoing hostilities in Lebanon. So classic assumptions, I think, in the law of war about where women are most vulnerable in war have centered around the practice and the advocacy of penetrative sexual violence. And I'm going to argue, as I've done in recent work, that these assumptions are ill-equipped to address the systematic targeting of pregnant, laboring, postpartum, and nursing mothers. From my perspective, we need to fundamentally reassess core imperatives that are driving the vaunted but largely ineffective women, peace, and security agenda. I think not only has this agenda been limited in its effects, positive effects of protecting women from wartime sexual violence. But I am concerned that by monopolizing global narratives of harm, it's eclipsed the broader range of violences, in the plural, that women experience in conflict. I want to start by saying a little bit about the law of armed conflict, and say that it's pretty well settled doctrine in the law of war that women and children hold special protections, which trace back both to the 1949 Geneva Conventions but predate them. These protections include the basic premise that persons won't be treated with what we would call adverse distinction on the basis of sex. And that concept of adverse distinction is essentially a non-discrimination clause in the law of war that prohibits discrimination on multiple grounds. In parallel, we see complementary protection for women under Geneva's 1, 2, and 3, Articles 12 and 14 in particular, which provide that women must be treated, quote, with all consideration due to their sex. Now, many of you who know me will know that I've taken issue with this patriarchal and honor-based language elsewhere. But even as I acknowledge that discomfort, I think it shouldn't take us away from the concurrent need to recognize that aspects of conception, pregnancy, delivery, birth, and post-delivery, postpartum, create inevitable vulnerabilities for women and children. And so to that end, states through their customary practices and treaties have determined that privileged treatment can be accorded in certain circumstances to women and the children they give birth to. Geneva 3, Article 16, and Geneva 4, Article 27. And expectant mothers have in particular, been the formal objects of protection under IHL, from Additional Protocol 1, which prioritized their consideration and early release from internment under Article 76, to the law that applies to occupied territory, where Geneva 4 requires expectant mothers to be given additional food based on their psychological needs, Article 89. So I want to recognize but move past the failure to implement and prioritize these obligations and protections by states. And I want to say that if we were to do that, it would be an important first step in addressing, within the scope of existing IHL obligations, the maternal and obstetric obligations that are already present in the corpus of armed conflict legal protection. That said, I want to talk about sexual violence and its limits. I think it's fair to say, and other speakers I know today will say it, that recent attentions, and I mean recent in the last 50 years or so, harms to women and girls in conflict has been generally positive and much needed. This has included things like recognizing specific crimes under the rubric of international criminal law that address sexual violence, judicial proceedings that address rape and other forms of sex-based and gender-based harm by the ad hoc tribunals and the ICC, and the Women, Peace and Security Agenda launched in 2000 by UN Security Council Resolution 1325. And even as I criticize that agenda, I would say it's had the laudable aim of mainstreaming gender in conflict prevention, management, and resolution. And it's been particularly high profile. States have both alluded to and placed themselves as sort of as protectors of and enforcers of the WPS agenda. One thing that's clear about that agenda, Resolution 1325 and its progeny, is that it has consistently stressed preventing sexual violence through accountability and puts sexual violence at the heart of its work. And some of that, of course, is good. It's brought institutional and normative attention to the scale, scope, and extent of sexual and gender-based violence experienced by women. But the overwhelming focus has been on penetrative sexual violence, rape. And what that has done, in my view, has moved attention away or allowed an eclipsing of other serious gender-based harms that are widely experienced by women during hostilities. It has both directly and indirectly created a hierarchy of gender-based harms in war, with rape at its apex, often at odds with the lived experience of women in war, who experience multiple and intersectional harms and have complex and varying views, as I have experienced both in my own work as SR and in my current work on the Commission of Inquiry on the Syrian Arab Republic. They have varying views on what the worst of the horrors that they have encountered. My current work starts from the proposition that it's critical to evaluate how the severity and cost of unseen violence that causes the same or greater brutality to women's lives and bodies needs to be surfaced. And that is a proposition that few policymakers or states have been prepared to take seriously, even as they talk the talk about protecting women and war. I claim that recognition and protection for maternal and obstetric harms is not an exclusive, or this is not a mutually exclusive trade-off with sexual violence and war. There's ample room to address both. It should be possible to advance women's protection from multiple sources of violence and prioritize the obligations of protection when women are pregnant, give birth, and are postpartum, as well as address sexual violence and war. But the reason why this rarely happens offers a lesson in the ways that one set of harms, sexual, occludes, excludes, and undermines attention to other harms, reproductive, obstetric, and maternal harms in war. So I want to be clear, I'm not minimizing the widespread use of sexual violence as a method and means of warfare in war, and I'm not arguing for less protection or justice or accountability for victims of rape in war. But I am arguing that feminist and international justice mechanisms must widen their aperture and see the full panoply of harms experienced by women. Let me say a couple of words about the logic of maternal and obstetric violence. We have to recognize that maternal and obstetric violence is central to the methods and means of warfare perpetrated against women by both state and non-state actors. The logic of military thinking appears, in my view, in multiple conflicts to use kinetic force against pregnant and nursing mothers in ways that are disproportionate and unnecessary. And moreover, this force is increasingly married with broader conflict tactics, such as drone use, AI and target selection, continual civilian targeting, constant displacement of the civilian population, and destruction of civilian infrastructure. This violence, this sort of cacophony of violence, leads to sustained obstetric emergencies, higher miscarriage rates, more hemorrhages, lower birth weight, and inability to nurse children postpartum. All of these outcomes negatively impact the survival rates of pregnant, childbearing women and their offspring in conflict zones. We've seen this logic of targeting mothers in Ukraine. We've seen over 2,000 attacks on medical facilities, to Gaza, where we've seen the rationale for systematic maternal and obstetric violence limited to military objectives of territorial control, erasure of people and culture, and spreading fear and terror among the civilian population. As all of us in this room know, maternity and childbearing are often lauded in traditional and not even all societies, and women are viewed often as the symbolic heart of the motherland. As such, women as mothers are central to military strategies to displace and erase people from disputed territories. Now, that said, the power of motherhood is deeply challenging for feminist scholars, as we've struggled for decades to argue for reproductive rights, autonomy, and independence for women and girls. We face immense backlash against women's human rights and equality, and we see the rise of traditionalism and political populism. Although today is a good day, it's post Orban's departure in Hungary. But that said, I think many women, and I want to say quantifiably not all, continue to self-define as mothers and view motherhood as maternal care as central to their identity, to their well-being, and their human dignity. The targeting of mothers as mothers by militaries is designed to destroy the identity and value of women as mothers. In my earliest work on gender-based violence during the Holocaust, this was the primary conclusion I drew from the deliberate separation of mothers and children in ghettos and concentration camps. Targeting women as mothers and children together is not new. It's been a feature of warfare since antiquity. What is new is a 2 decades old political focus on penetrative sexual violence and war, which has, in my view, obscured the scale of maternal violence and harm occurring in the same theater. And I think this occlusion is part of a long-standing concentration on what we might call high-profile, extraordinary violence against women, which has diverted attention away from the more regular violence that women routinely experience in conflict and post-conflict societies. The misguided, I think, concentration on one form of harm eclipses the connection between daily experiences of life cycle violence, cumulative and intersectional violence that pervades conflict zones. So I'm at time, and I'm happy to stop there and speak more about some of the examples in the Q&A. Many thanks.
Great. Hi, everyone. Good morning. Thank you for being here on a Monday morning at 11 o'clock. It's good to see everyone. And hi, Finola. It's good to see you. My backstory is that while I was in law school, I worked with Finola while I was a clinical student way back when. I think it's like 5 years ago now, and also with Elisa, who's going to be on a panel later. So it's good to finally be with them in the same space. Thank you to the Minnesota Journal of International Law for having me and for being so welcoming and for convening this really incredible symposium on issues that I'm just really excited that are finally being paid attention to by groups of students at law schools. So I figured I'd start speaking by giving a background on my personal experience working on these issues and kind of give a lineage. And I think that would actually track well with how the field has developed over time in international criminal justice. I'm mostly going to be speaking about international criminal law because that's my area of expertise, as well as genocide more specifically. So as I mentioned, I went to law school at UC Berkeley from 2020 to 2023. And during my first year of law school, Alexa Koenig, the director of the Human Rights Center there, had convened a group of students together to start thinking about the possible methods of accountability that could be pursued for the reproductive violence that was underway in Xinjiang against the Uyghur population. So for those who don't know, the Uyghur population is an indigenous Muslim minority in the Xinjiang autonomous region in China that has been subject to systemic and ongoing reproductive violence since approximately 2017 and on an ongoing basis, although a lot of our access to what's been going on in Xinjiang has been closed in the last few years because of tightening restrictions on media from inside and outside of the country. So all to say, the group's work actually did not go on for that long, but I became fixated on the plight of the Uyghurs for many reasons, but most specifically because I was curious as to why there seemed to be very scant international attention about what seemed to be really clear and obvious atrocities that mimicked very similarly what we saw in the concentration camps in various atrocities in the 20th century. So I eventually wrote a paper in which I examined accounts of enforced sterilization and forced abortion in Xinjiang that came out of the Uyghur People's Tribunal, which was a people's tribunal that took place in London. I believe it was in 2022. Which is people's tribunals, for those who don't know, are non-official tribunals that seek out witness testimonies and adjudicate possible international crimes when formal accountability measures are not available. And I argued in that piece and in my prior research that the reproductive violence that was underway in Xinjiang was quote unquote invisibilized in two key ways. The first is that it was quite literally hidden. The forced sterilizations and forced abortions typically took place in these quote unquote re-education camps, which are better understood really as concentration camps throughout the region. And so quite literally, we can't see the violence that's happening. They happen in healthcare clinics outside of the camps, and then they happen behind large walls within the camps. And the second is that I found by speaking to various experts on the Uyghur situation and by combing through the witness testimonies at the Uyghur Tribunal, that the violence itself was also variable and dynamic in ways that international criminal lawyers have not previously considered to be the case with forced sterilizations. So many women had reported being subject to physical force, which is perhaps in our international law, legal imaginary, the kind of force that we typically imagine to take place when we think about something like enforced sterilization or forced abortion. And by this, of course, I mean, the holding down of women or individuals in healthcare clinics and then forcing them to undergo procedures without their consent. But then there were also several accounts of women experiencing the procedures under duress, such as the threat that their partner is going to be removed from the country. And then also accounts of fraud in which they go in for a procedure that under false pretenses, thinking it was a different procedure, and then they come out having been sterilized. And then also in several cases, women had claimed that they consented to the procedures, or certainly the PRC, the People's Republic of China, the Chinese government had claimed that myriad women had undergone the procedures consensually. And so this provided me with a really strange puzzle. And so what I mean by all of this is that the reproductive violence that was and is continuing to be underway in Xinjiang was not only literally hidden, but in some cases, the narratives of violence occurred outside of our collective legal imagination of what reproductive violence looks like or should look like. It was particularly strange for a number of reasons. It was happening outside of the context of war, which is different from sexual violence, which, as Fionnuala accurately described, is typically we understand to be a phenomenon of war, or when it occurs as genocidal rape, typically happens during a genocide that's ongoing within an armed conflict. And also, there was particularly little prosecution of forced sterilization in international criminal law over time. And because the law requires adjudication to develop, we had seen in the international criminal tribunals that preceded the ICC that sexual violence had grown to encompass in the jurisprudence a recognition that the forced component of rape can be fulfilled by evidence of coercive circumstances, right? And so typically coercive circumstances, as understood at the ICTR and the ICTY, as including the context of war, that war is inherently coercive. And so a rape can be committed by perpetrators against the victims of another group within those coercive circumstances, but that the lack of consent does not necessarily need to be proven for adjudicative purposes. But this has not been considered with regard to forced sterilization, I found, and made narratives around reproductive violence in Xinjiang particularly tricky to pin down. And so the lack of adjudication, as is always the case with law, kind of left a lacuna, it left gaps in our understanding of what reproductive violence could look like. And arguably, the circumstances in Xinjiang were tremendously coercive and continue to be tremendously coercive because they are ubiquitously propagative. And so arguably, like rape in the context of war, it is impossible for women, even in a state of peacetime, outside the context of war, to undergo those procedures consensually. So this is not something that the law has necessarily caught up to, but it's not for lack of possibility, it's simply for lack of jurisprudence. So a little bit of doctrinal overview. I realize I've thrown a lot at you so far, but I'll step back. Actually, the first time that I presented that piece on the Uyghurs was at the mid-year meeting for the American Association, for ASIL in Miami in 2022. And I was put actually on a panel with Lisa Davis, who at the time was promulgating the draft version of the Office of the Prosecutor's policy on gender-based crimes, which I know was mentioned in the last panel. So prior to that policy, we didn't have a definition of reproductive violence. Simply put, reproductive violence can be understood as having been codified in the Rome Statute under three primary provisions. The first is forced pregnancy as a crime against humanity and as a war crime. The second is enforced sterilization specifically as a crime against humanity and a war crime. And the third, arguably the largest, the least narrow provision, which is imposing measures intended to prevent births within a group as an act of genocide. But then in 2023, the Office of the Prosecutor of the ICC promulgates this policy on gender-based crimes and provides us with a really nifty and useful definition that I'll just read to you here. Reproductive violence violates reproductive autonomy and/or it is directed at people on account of their actual or potential reproductive capacity or perceptions thereof. And then the policy goes on to further specify that other acts can be prosecuted as reproductive violence beyond those three specifically enumerated in the Rome Statute. What's important to recognize is that this is a policy category, not a jurisprudential category. So that provides us with a number of issues. The first is that for those who might imagine that reproductive violence can be prosecuted in a better way to reflect victims' experiences within armed conflict or in crimes against humanity or in genocide occurring outside of armed conflict, that requires thinking about the law expansively and as encompassing the kinds of harms that Fionnuala just described, as well as other harms that we have typically considered to be endemic to war and to genocide, but that we haven't traditionally considered as being part of this policy category of reproductive violence. And so my work, especially through the Human Rights Center at Berkeley, has since zoomed out. I used to think of reproductive violence quite granularly and thinking about the different ways in which forced sterilization can manifest or forced abortion can manifest. But now, especially at Berkeley, we're far more interested in thinking about these different types of reproductive violence that can occur. And so most recently, we've been conducting expert interviews with healthcare experts, physicians, investigators, sexual and gender-based violence experts. And what we found is that there is actually very little agreement about exactly what encompasses this policy, this non-jurisprudential category of reproductive violence. So we've kind of started mapping out these various ways in which reproductive violence can manifest. The first is that, contrary to this specific panel's name, which is Beyond Sexual Violence, is that, of course, as we know, reproductive violence can occur through sexual violence. And so this is what we understand as genocidal rape, in which the rape is committed with an intention of destroying the group. This could be through forcibly impregnating women with the children of the perpetrator, or through making it impossible or culturally unviable for the woman to bear children with members of their own group. And then second, non-sexual forms of reproductive violence. So this includes sexual or enforced sterilization, forced abortion, even the separation of sexes by perpetrators in order to prevent members of a victim group from reproducing. And then third is this denial of reproductive health care, which has been the particular focus of our recent work at the Human Rights Center. So we've taken a particular interest in this because we found in speaking to physicians and healthcare experts that they actually thought of reproductive violence very differently than we as lawyers might expect. And we've called this kind of category of harm infrastructural harm, because they see their role in conflict, these physicians who are typically working on the ground in conflict zones, as really being frustrated, or access to maternal care being frustrated, not only when hospital attacks are targeted or destroyed attendant to conflict, but also when there's a threat of those attacks coming, when there's an expectation that those attacks are going to come. And so healthcare groups have to do various things in order to account for the possibility of those harms, such as separating their clinics miles apart. You can imagine what happens when you put the maternity ward and the intensive care unit for infants 2 miles apart from each other. When you put the OBGYN clinic in one village or region, and then put adult internal medical care in another. It makes it really hard for women to receive necessary care that can arise in complications prior to giving birth and postpartum. So another way that we found that doctors were really interested in seeing the law encompass their actual lived experiences on the ground is through the destruction of other kinds of infrastructure that go beyond specifically hospital attacks. So the destruction of a bridge that makes it impossible for healthcare workers to actually access women in villages and being able to get to them, because more often than not, women who are seeking maternal care during conflict are far too scared to actually go out of their way and go to hospitals and actually receive these types of care. They are not considered, not only by physicians on the ground, but also by the women themselves, as non-essential services, because they would like to stay alive. And if there's the threat of an attack coming, or if an attack frustrates their ability to get to essential care, they see it as really impossible to access it. So why does it matter to map reproductive violence into these various ways? Well, it matters for a few reasons, and so I'll leave you with these. The first is that understanding the full scope of how reproductive violence might manifest as sexual violence, as non-sexual reproductive violence, and as infrastructural harms matters because it lays out an agenda for investigators working in international criminal justice. So the international criminal justice community has started growing increasingly reliant, and for good reason, on digital open source information in their investigations. So for those who don't know, and open source information is any information that you might find online on social media or in digital media broadly. But this kind of violence has traditionally presented a blind spot for open source investigators working in international justice. As I said, with the reproductive violence underway in Xinjiang, that violence is necessarily private. It's interpersonal and it happens behind closed doors. But we would like to argue that, or I would like to argue that reproductive violence is not outside of the scope of open source investigators' work, and that open source investigators are not off the hook in international justice efforts to hold to seek accountability for reproductive violence. And that is because infrastructural harms are necessarily public. They happen online. In fact, many of the open source investigators that we spoke to, or many of the investigators at the UN that we spoke to, said that almost all of their evidence about hospital attacks was exclusively dependent on open source information, meaning that the way they were substantiating their claims about healthcare attacks in Gaza, in Myanmar, in Sudan, in Ukraine was almost exclusively through access to open source information. So that's the first reason, is that open source investigators have something to contribute. Digital investigators working in formal mechanisms at the ICC, in UN investigative mechanisms, or standalone investigators have something to contribute to these efforts. And the second is that to take reproductive violence really seriously, and this is the subject of most of my current work and hopefully my future work, requires, in my view, recognizing the special relationship between reproductive violence and genocide. So, of course, genocide can indeed be committed primarily or exclusively through reproductive harms, as we've seen in Xinjiang, or arguably also in Peru in the late 90s under the Fujimori regime. But even where there are other acts of genocide present, such as killing, these types of reproductive violence, such as infrastructural harms, may provide actually better evidence of genocidal intent than what we typically consider relevant. So prosecuting genocide, of course, typically requires a finding of specific intent, and that relies on circumstantial evidence, which requires proving that a pattern of conduct, that the only reasonable inference you could take from a pattern of conduct is that there existed an intent to destroy a group. And I would just like to highlight that it is not by chance, I don't think, that 4 of the major conflicts that have seen an unforeseen amount of attacks on healthcare infrastructure have also been subject to considerable debate about their definition as being genocide. These are, of course, Myanmar, Sudan, Gaza, and Ukraine. And when international lawyers have typically argued that these 4 conflicts qualify as genocide, they actually don't always point to the number of people killed or to the traditional means and methods of genocide as we imagine them. They typically point to the destruction of healthcare. And so we might also recognize that there's something different, that there's something more obvious about perpetrators' intentions to commit genocide when they commit violent acts on healthcare infrastructure that frustrate the ability of victim groups to receive necessary reproductive care. I'll stop here because I'm sure I'm over time, but thank you all again.
Thank you, Fanula and Anthony. I have a couple questions, one for each of our speakers. Then I will look to the audience to see if there are any questions, and then return to our speakers for questions and see if they have any questions for each other. Since Fanula is away, we don't have lunchtime to sit around a table and chat, so I want to give our speakers a chance to engage as well, which is often a very productive part of these gatherings. So first, Fanula, thank you for sharing your research and your reports and what you've been working on. I'm thinking about Oliver Wendell Holmes. You maybe didn't think I was going to go there, but he talks about the bad man. And if you want to know what the law is, he says, you look to see what the person who has a mind to breaking the law does. And if it changes their behavior, then you have a good idea about what the law is from the bad man. And I'm wondering if that applies at all. I mean, what you're talking about seems to be a crime that has been occurring for decades, centuries. But is there a component to it in which we have a series of laws now about rape and penetrative violence that is well known? It is risen to a level of consciousness that everybody has in their mind, this is wrong, this is bad, we need to focus on this. And then the strategies of the perpetrators has changed and is moving to maternal and reproductive issues? Or is it just the law is simply behind the times and it is, this has always been going on and the law needs to adapt?
Yeah, I mean, I think a couple of things are true, right? One is that the law that we have, the law of armed conflict that we have, was produced in a context and a time where women's status under law, for example, their right to own property, their right to be seen as autonomous, dignitary human beings, um, either didn't exist or existed in diminished form. So the law we have, going back to the customary international law of war, but even the early treaty regulations, the Hague regulations, even 1949, many of the states sitting down to write that phrase without adverse distinction were states where women were like not equal under law in national legal systems. So I think one enormous challenge we have in the law of armed conflict is that it has this sort of historical baggage of exclusion, and it's constructed out of a highly patriarchal set of assumptions and norms about women and women's bodies and equality in society. So in that sense, it's structurally behind. Its DNA is constructed in a way that does not take account of sort of female bodies or differently gendered bodies. So I think that's one enormous challenge, right? I think a second is, I think it's certainly true that NWPS agenda has certainly widened the aperture of knowledge around sexual violence. But the extent to which that is translating into practice, right, that it's operating as a barrier to the commission of certain kinds of offenses is, I think, really quite open to debate, right? If one of the goals of introducing language was to seek prevention, I think one of the challenges many of us in the field are kind of contending with is whether, in fact, then the language operates as an enabler or a constraint, right? So that actually the presumption we have that more legal language prevents violence is, I think, a really complex question as to whether or not that is in fact true. I think the third is just a contemporary challenge. It's not just true of gendered violence of all the kinds that both Anthony and I have described, but it's just the kind of permissibility of war, right? The complete and utter abandonment of rules. We're seeing it, of course, in the current conflict in Iran, in Lebanon, in Ukraine, where the idea of restraint, the thing that prompted the creation of these norms, like fundamentally seems to have lost traction, at least with leaders, and is posing like very fundamental questions about whether a commander on a battlefield would refuse an order to commit what is a manifestly unlawful order because it implicates some norms that we in the body of international lawyers would assume is obviously illegal as a matter of international law. So I think we're stuck with all of those challenges of implementation. So it's not just right, it's the construction, it's the action, and it's the enforcement, which I think is for many of us forcing a really uncomfortable encounter with the relevance of law in this space. And that's not a good place for us to be, even as we're arguing for like enforcement and norm restraint. Thanks.
Thank you, Fionnuala. So my next question is for Anthony. Anthony, you, towards the end of your talk, began to talk about open source investigations. And I wondered if you could expand a little bit on that in terms of what kinds of things we need to be seeing and thinking about in the field. And in particular, I'm interested in this nexus, this contact point between researchers and the data that we need as researchers to identify what's happening out there. And since you're on the ground and really focused on these issues, could you offer us some insights about the landscape and the need for any changes you see within that landscape?
Yeah. It's okay. It's just
yeah, thank you.
Oh, okay, great. So yeah, no, of course. So on the question of open source investigations, so so for those who might not know, right, international criminal justice has become increasingly reliant over the last decade on open source information, which involves digital investigators combing the internet, combing social media for publicly accessible information, typically found on social media or on chat channels, depending on the country that the violence is taking place in, to find evidence of violence. This could be textual evidence, such as written admissions of violence. This could be photographic evidence that's accompanying text that explains what's happening in the photo, or this could be video evidence that even has sound accompanying the description of the violence in text. And so when we're talking about reproductive violence, it's typically been considered that reproductive violence falls outside of the scope of these kind of new advanced technological innovations and investigations, because we typically imagine reproductive violence, as I said, to be sexual in nature, and so to be happening behind closed doors or potentially unfilmed, even if it's not sexual. So the first thing that I would say is that as researchers, these kind of more public harms that me and Finola have described, attacks on healthcare infrastructure, obstetric harm, the denial of access to essential services during conflict, all of these can be proven remotely and require less effort than we typically imagine traditional investigations to require, including, for example, the triangulation of evidence, which requires speaking to witnesses on the ground and validating and confirming the veracity of the evidence with individuals who may have witnessed the violence, and so on and so forth. So what researchers should be aware of is that there is a whole host of information that exists online that could be used to seek accountability for crimes that disproportionately harm women in ways that researchers have not previously considered. The second thing that I would say is that doesn't remove a great deal of the ethical dimensions around these kinds of investigations. So especially when we're thinking about the kinds of reproductive violence that take place over the course of or through sexual violence, one of the things that we've worked on the Human Rights Center, and I've had the privilege to contribute to drafting, for example, is the open source practitioner's guide to the Murad Code. The Murad Code is a global code of conduct promulgated by the Institute for International Criminal Investigations that provides global standards on how to conduct traditional investigations into sexual violence. But that code, for instance, was lacking in specific provisions detailing how researchers might deal with open source evidence of sexual violence, which is to say evidence of sexual violence that appears in digital or video format online, or in photo or video format online. And so there's a great deal then of ethical considerations that a researcher has to consider before pursuing work like that, especially standalone investigators that might not be working with the resources that are required to really do such an investigation ethically. And these issues revolve around consent to use the photo or video evidence, without which the use of evidence and accountability procedures might qualify as a second violation on top of the sexual violence that occurred against the victim. And so really thinking through what researchers that are working standalone or in small groups of NGOs or in larger organizations have to contribute to these efforts is really important, not only from a practical accountability standpoint of actually pursuing these investigations purposefully and considerately, but also in terms of the ethics surrounding them, because it's not just, it's not an easy call to make when these investigations are appropriate, but they're necessary nonetheless.
Thank you. I'd like to open it up to see if there are any questions from the audience. Yes, in the back.
Yeah, mainly I wanted to know, especially for Anthony, if there's any gold standard legislation in terms of regulating violence online, like what would be psychological or any other type of violence regarding women's rights, specifically in this new framework that's been rising on technologically facilitated violence against women, and if that has also kind of cross paths with obstetric violence in any kind of way, or is that something countries are catching up to and is mainly in the realm of legal theory from legal academics and NGOs?
Yeah, that's a really excellent question. So I'm not sure about a gold standard. Of course, in international criminal justice, we typically consider the gold standard to be policies promulgated by the International Criminal Court's Office of the Prosecutor. And I believe that there have been a number of reports produced by the OTP regarding technologically facilitated harms or harms that might be sexual or gender-based in nature that happen online and on online platforms. That's not necessarily the area of expertise that I have. But I'm also under the impression too that the OTP has previously, in the last few years, reduced its operations with its technology advisory board for a number of reasons. But yeah, so unless Finola knows better, perhaps, than I do, my understanding is that there hasn't been a formal policy report by the OTP detailing exactly what kind of harms would be produced, but there has been a lot of research being done by international criminal law scholars regarding what the four core crime or what the three core crimes outside of the crime of aggression might look like in online spaces. And I think most recently has been cited in at least one policy report by the OTP, for which I can't remember exactly what the scope of the report was, but I think referenced some of that scholarship.
Fanula, were you able to hear the question?
Yeah, no, I was. I guess I would just say I think we are yet to fully grapple with the sort of implications of how we move, including the definitions of crimes that include kind of embodiment onto new technologies. And there's a colleague of mine at Queen's University Belfast, Sarah Zamsky, who's just about to publish a book with OUP that I highly recommend for people interested in this question, that really tries to grapple with how you map on to the kind of traditional, particularly crimes against humanity, as a category, how you map on online crime, both in terms of can an online crime that includes a sexual violence element meet the threshold, but also the role that online technologies are playing in both amplifying, assisting, and facilitating the commission of these crimes. So there's like clearly a really emergent space. I don't know that we have a gold standard yet, but we definitely have serious engagement by scholars and some engagement by the ICC, by the Office of the Prosecutor on these issues.
Sarah Zarmsky is exactly the person I was thinking of, Finola, who I think, and if I remember correctly, her work was cited in something produced by the court recently. I just can't quite remember if it was in a judgment by the appellate chamber or whether it was in some kind of a policy report that was produced. But yeah, that's whose work I would look towards if I was interested.
Are there other questions from the audience? Yes, Nikita.
I will also try to project. I'm not as good as Alex at doing that, but Professor Nealon, I know you mentioned the lack of diverse gender perspectives in the drafting of the treaties. But I was wondering if this sort of advocacy over obstetric violence has any sort of historical context, because I'm sure that a lot of sexual violence has been obviously silenced throughout history, but if there's any kind of understanding of patterns over time of this sort of violence that can inform legal perspectives, or if this is a newer phenomenon. This is the first time I've kind of learned about this, so I'm just curious whether or what light history has to shed on this.
Sure. I think there are complicated histories in the plural. So certainly if we look back, for example, to the Nuremberg era, you recognize, although obstetric and sexual violence wasn't prosecuted at Nuremberg, and there were obviously prosecutions in the Tokyo trials for sexual violence, but if we just focus on Nuremberg, we see a kind of a stealth recognition, particularly of obstetric harm in the doctors' trials, because of course the medical experimentation that was part and parcel of the doctors' trials had a reproductive and an obstetric element. So it's there, but it's there obliquely, not named as gender-based violence, and also certainly not focused on the harm to the woman in its full cultural and social context. So it appears, but it appears obliquely. So we've had some recognition in international criminal law, but it's been patchy. I think the other thing I would say is that there's a really interesting history in the travaux préparatoires of the conventions, because if you look at who was interested in inserting protection for maternal and obstetric harm into the conventions, it comes from a very particular place. it comes from the Vatican, and it comes from an alliance of more conservative states. So when I alluded in my remarks to the complexity of feminist engagement with maternal and obstetric harm, one of the things we have to remember is those provisions that I'm acknowledging have this sort of create this doctrinal basis for us to argue for state enforcement and for some greater dissemination and practice aren't kind of they're not clean. They come with very particular ideologies of the role of the women in perpetrating the next generation of fighters, of women's role in the reproduction of the nation, as it were, in its sense of fecundity and reproduction, women's body as a vessel for that. So that recognition of maternity, as I said, runs up both theoretically and historically against a set of things that are very uncomfortable, rightly so, for feminist scholars, and are located in notions of the woman's connection to a child and the woman's role in society that's just not value-free. So there's a really rich history there. I would also recommend the ICRC has just released its updated interpretation of the Pictet commentary on the Fourth Geneva Convention. And I think there we see an attempt by the ICRC and scholars, and I was a part of that process. So I think I and many other feminist scholars who contributed to that reinterpretation have tried to sort of rethink what it would be like to interpret these treaties without some of that baggage. But I would still say there's baggage, right? You can't kind of get rid of all the DNA. But I encourage people to look at the history, because obviously when we take these norms, we don't want to take them as value free. We have to understand that they're both useful to us, but they have complexity. And it's both of those things I think are important to acknowledge as we move forward, particularly normatively, to address obstetric and maternal harm.
Thank you. Anthony, do you have anything to add to that? Or? Okay, great. Other questions from the audience? Yes, please.
Hi, Fionnuala. It's Elisa. Great to see you. I have a question for both of you, which is on this point, Fionnuala, you made on legal protections not necessarily equating to more prevention, right, and actual impact. So this has been a fairly legalistic conversation, and I so support all of the pushes to actually enumerate these crimes and name what we should prevent and punish. But what are the other levers here for advocacy? Like, what are the political levers for change, the more social dynamics here? Just what advice would you give this room of potentially a room of future human rights champions who might not just be litigating or part of the jurisprudence?
Super. Thanks, Elisa. I have many debts to Elisa, so I'm sorry I'm not in the room to repay at least this question in person. But to acknowledge several things, you're right, absolutely, Elisa. Like, this is not just, I don't think this enforcement argument is one doctrinally. Like, we do the doctrinal work, we do the treaty work, and there's certainly a role, I think, for augmenting norms here. And I think in yours and in my engagement with states over the last several years, what we've seen is that there is a receptivity to arguments around obstetric and maternal harm. And that's complicated in the same way that the reception and the receptivity to argument around sexual violence is often actually coded in patriarchal ways. Like, why do states, particularly patriarchal states, respond so fulsomely to arguments around protecting rape and war? It's in part because they're digging in both emotionally and psychologically into tropes of purity and modesty and protection of women, what Laura Schoberg calls the protection racket, right? So I do think the arguments are not just legal arguments. There are gender tropes and gender orders here that do work, I think. And as feminists, we walk this really tight line where we understand that a power of an argument of protection, especially around women and girls, can actually leverage these pre-existing pathways for us that can, in some sense, augment protection, but also sometimes can have this inverse and unexpected outcome of reinforcing certain kind of gender orders for women and for men about what it means to be protected in conflict. So I do think you have to do this work legally. I think we do it politically. I also think, and I say this, obviously many folks in the room know I'm a mother. What attracted me to doing this work was recognizing both professionally and personally how deeply and profoundly motherhood changed me and what a harm to one of my kids would mean if I were in a war, and how that harm would and speaking to mothers, as Elisa, you and I have done over many years in contexts where we're recognizing also that, to quote Robin West, many women are essentially connected, and that connection, both biological, but also the role that women play in, I want to say mothering. I think mothering is not gendered female. Mothering can be gendered in many, many different ways. And it's, I think, as an advocacy strategy, thinking of the multiplicities of mothering, which is done by men as well as by women in society, that kind of set of ways to think about care in society, that those are really powerful advocacy tools to argue for better protection.
And we have about 2 more minutes, so I want to give Anthony the last word.
Great. Okay, that's actually always really important for me because I'll always speak longer than 2 minutes. So 2 points on that, Elisa. Really thoughtful question. The first is to just kind of affirm what you said. I think something that we saw with the public responses of the Chinese government to accusations of genocide when it came to the reproductive violence against the Uyghurs is that, you know, this kind of use of the law to make excuses or justifications for violence that are underway. And of course, the law is always going to have gaps in it. So one of the dangers, of course, of over-legalizing or detailing exactly what kinds of harms might constitute a certain base crime or category of crime can actually also be seen as granting a permission slip for states to be able to, you know, evade or elude the law. And so there's actually there's really a potentially, dangerous outcome that can come from being far too specific in our methodologies or typologies for thinking about these crimes outside of like purely theoretical scholarly purposes. And so that's the first thing. And the second thing is that I think what we can do in response to that then is to recognize it's recognizing as a community of practitioners or as scholars that we are subject to biases about what atrocity looks like. And so some of the harms that Finola covered are crimes on the books on their own, such as starvation or detrimental destruction of civilian property and so on. We typically think of these as existing in a ranking. Even if we don't consciously think of these as existing in a ranking, we respond and we speak about certain crimes as being more atrocious or spectacular than others. And so checking each other, and I think having conversations in which we recognize the sheer horror of crimes that are banal, that are structural, that take place over time rather than immediately and spectacularly in a single episode of violence is really important for understanding exactly how we might respond to them with the attention that they deserve rather than treating different crimes differently simply because of our aesthetic biases about what they ought to look like or what they do look like.
Please join me in thanking our speakers.